Dugan Kelley is co-founder of Kelley Clarke PC, which is a boutique law firm with a national presence. He chairs the firm's securities and real estate practice group, where he focuses on assisting clients of multifamily, commercial, and residential acquisitions and sales. He has structured acquisitions in excess of $2 billion. With more than 20 years of experience, Mr. Kelley helps us understand some of the important legal aspects of both the real estate transactional and securities sides.
All right. Welcome, Dugan Kelley. Welcome to the show.
Hey, thank you for having me. Hey, everybody. Happy to be here.
Thank you for joining us. So, Dugan, why don't we just go ahead and tell our listeners a little bit about your background and how you transitioned into real estate?
Sure. Happy to. So I'm a full-time lawyer. We're a boutique law firm with a national footprint. What that really means is we have strategic offices. Our offices are in the Dallas-Fort Worth area in Texas, and we also have an office in the greater Los Angeles area, in a small town about 90 miles north called Santa Barbara. And we do a full service firm, but my personal practice is almost exclusively in the area of real estate transactions, securities work, everything involving essentially kind of most of the time I spend my time in the holy trinity of non-recourse debt of multifamily, self-storage, and mobile home parks. And so I've been doing that for 4 or 5 years. I haven't always been a real estate lawyer. I haven't always done transactional. My primary, when I first came out of law school, was a litigator. I thought that it was going to be exciting to be in the courtroom all the time, representing people that have been falsely accused of crimes, trying to change the system, doing things like that. And I did that for a long time. And what I realized was that whether you were a criminal defendant or a civil defendant, or you were trying to sue somebody for something, it was the unhappiness business. Everybody that was involved in litigation, didn't matter what it was, they were unhappy and miserable, and nobody seemed to enjoy life. And I started representing more and more developers, entrepreneurs, people that wanted to gain their financial freedom in the area of real estate. And something clicked for me. And it was, when you see some excitement and they do their first deal, they get that first meaningful check, something that actually helps them transition from the 9 to 5 to doing something where they're able to generate passive income. It was something that was very attractive to me personally. And so we've made it a strong mission. One of the foundations of our firm is to help people get to that place where they can enjoy financial freedom. And we do so through providing services to them in real estate or securities work.
And now your role in relation to real estate, are you more so as a service provider, kind of partner in that sense with real estate syndicators, or are you a syndicator as well, or kind of just a combination of both?
Yeah, so I have personally syndicated deals. I've also bought commercial pieces of real estate with my own money. So I'm an owner, syndicator, an investor. But what I do most of the time is I'll get a text or a call from a client who says, hey, I got an LOI accepted. Either I need you to do the purchase and sale agreement, or expect us to receive the purchase and sale agreement. I need you to look at it and make sure that it protects me. So we're engaged very early on the process in what we call that road to ownership. The road to ownership, as you know, can be curvy, sometimes crooked. At every given stage, there are things that you really require a strategic team member to help provide guidance or options, give you solution-based kind of things to think about. So that's what we do. And then during, obviously one big phase of that road to ownership is the securities piece of it, getting that private placement memorandum offering going, making sure that the investors have all the necessary docs that are necessary to get the money out of their bank account into your bank account so that you can therefore buy the piece of property. So we do all of that whole road to ownership, the real estate side and the security side for most of our clients.
So could we just, I guess, just start with kind of like a high level overview here, especially for a lot of like the newer people that are out there and listening. So you just mentioned, because a lot of people, I think, when they think of an attorney, well, like you said, the first thing that comes to mind, like a litigator. Okay. The next thing you said, well, real estate attorney, right? But then you also mentioned securities, right? So you mentioned there are actually a couple different aspects that are involved when we're talking about real estate transaction, when we're looking at syndications, right?
Right.
So, and these two are not the same.
They aren't the same.
Mm-hmm.
That's right. That's a perfect point, because many of my colleagues in the security space, they don't do the real estate side. That's not their gig. They don't want to do that. Perfectly fine. And so what happens is most clients end up having to hire two sets of lawyers. One set of lawyers, let's say the real estate side, that's the lawyer that will help you negotiate the terms with the seller, the purchase and sale agreement, your due diligence period. What's the earnest money? Is it hard or not? When do I have to close? Are there any extensions that are baked in there? What are the costs? Who's going to pay for what at closing? And then ultimately, when you get your leverage or debt with your lender, the lender is going to have a big set of attorneys, and those attorneys are going to give you a list of saying to your attorney, saying, I want all of these things to be done in the negotiation with the bank and the bank's lawyers. And so your real estate lawyer negotiates with the lender's lawyers, the loan documents and all of those things. And then ultimately there's another set of negotiations even after that. And that's called the conveyance and transfer aspect. And that is the formal transfer of ownership from the seller to the buyer to you. And so that's kind of encompasses the real estate side of it. And then on the other side, you typically have a securities attorney. And if you're not using the same firm, then that securities attorney, so you engage that securities attorney. That securities attorney creates the entity that will ultimately be the borrower. So remember, when we talk about syndication, it doesn't need to be terribly complicated. Most of you that own your residential homes had to show up at the closing table or the title company or with the closing lawyer and give them a small percentage of the overall purchase price. That's the equity or your down payment. Right. Well, in the concept of multifamily, that down payment is massive. It can be. It could be millions of dollars. Where do we get that money? This is why syndication is an amazing concept, and that is, well, what we do is we pool investors' money together to reach down payment to then essentially show up at the closing table. That syndication of the down payment. That's what we talk about when we talk about having to do securities work, because what we're really doing is we're selling a piece of the borrower. The borrower is often a limited liability company or a limited partnership. Sometimes it can be other types of structures, but that's the basic premise. And so your securities lawyer has to provide all of the disclosures. It has to create the entity that will ultimately be the borrower. It has to create the questionnaires or the suitability documentation to make sure that this is an appropriate investment for your potential investors. It needs to create the legally binding document that actually obligates the investor to give you the money and for you to give them a piece of your company. And then it sets forth essentially the only living document that exists post-closing, post your acquisition, and that is called the operating agreement or the limited partnership agreement. And that governs how the investor plays throughout the life cycle of the asset. Meaning you as the sponsor or the syndicator, you want to be in control, likely, of the asset throughout the entire life cycle, from acquisition until ultimately liquidation. Well, the only document that really governs what you can do and what you can't do and how you interface with your investors is that operating agreement. And so your securities attorney should assist you in the preparation of that to make sure that it actually matches what you want. And that's typically what a securities attorney does. So we do both. We do all of that. We do the real estate side and we do the security side for most of our clients.
Now, if we could just circle back really quickly to the real estate side. Now, given the overall circumstances with this entire pandemic scenario, right? What would you say, like going forward? Because I mean, we're still in the midst of this pandemic, right? For people that are looking at doing deals in this environment, what are some important, I guess, clauses people might need to consider including in their PSAs, going forward?
That's a great question. It's very important for people to understand that the deals that we were doing in December and January of this year are not the same deals that we're doing in March, April, and May, which means before the pandemic, sellers, it was a very hot market. Sellers had an expectation and they were able to obtain from buyers hard money day one, very tight closing timetables, maybe with very little contingencies, meaning unless the seller was unable to marketable, insurable title and a clean environmental, meaning that this is not a toxic waste dump that we're buying. The seller had an expectation that the buyer was essentially locked into the contract, and whatever the earnest money, and in some cases, depending on the size of the acquisition, this could be hundreds of thousands. I've had clients that went hard $1 million on day one. So you're talking about lots and lots of money. The reality is now with the pandemic, sellers, at least seasoned sellers, understand that due diligence periods are expanding, meaning we have to give sufficient time to be able to travel safely to the properties, to be able to physically inspect them. We have to honor tenants' rights as to whether they're going to allow our third-party inspectors or our contractors that we hire to actually physically inspect the units and do so in a safely manner. And that time period that historically has been very short before pandemic is now longer. And also the capital markets. So those of you that are engaged in looking at, well, how do I get debt, right? And you maybe have talked to a mortgage broker, or you're looking at this, the stock market, it's going up and down, or you're looking at what banks are lending. The reality is, whether you're a federally backed agency lender, Freddie Mac, Fannie Mae, or HUD, it's sluggish, meaning it's very difficult. They're able to be more picky about the types of loans that they're willing to lend on. The same thing in the bridge space. Some of historically what I would consider to be gold standard bridge lenders have been very tight, and they basically ripped up underwriting in the midst of the pandemic. They threw it in the trash, and then they decided that they were going to be much more strict, meaning demanding that you're going to upfront deposit into interest reserves a certain portion, could be almost a year, maybe longer, of debt payments into escrow, basically to bolster their collateral, their position with the property. So what does that do? Well, again, seasoned sellers, buyers have to negotiate with the seasoned sellers, financing contingencies, or an allowance to allow the lenders additional time that they're going to need to underwrite this property. So remember, you going out to the property and physically inspecting it is one thing. The lender and the lender's team also, during that debt process, goes out to the property and inspects it. And often those inspections are not at the same time, meaning you physically inspected the property early on. Now you've gone and obtained a potential loan from your lender. Well, your lender wants to send a team. And if your lender most often is not in the town in which the property is located, then they're also flying into the state where the property is located. So all of that means that the time frame for lending needs to get larger. So time frames, amounts of earnest, whether it goes hard or not, those are key clauses that you want to do. And then also you want to think seriously about whether you want what we call a force majeure clause. Force majeure clause is essentially a fancy legal term that allows you to rip up the contract, or the ability to rip up the contract and get your earnest money back if an event occurs. So remember, we're in the middle of a pandemic, so you think, well, let's just put a force majeure clause that says if there's a pandemic, then I get to rip up the contract. Well, we already know that, right? We already know that there's a pandemic. So what we do is we have to be smart about what our force majeure clause means. And it needs to be something like, well, if there's a national quarantine that gets put into place, or the capital markets get shut down, or the stock market tanks, or you see my point? We're only limited by our lack of creativity on what that force majeure clause really means, and at what point do we need to trigger it? Because it's not fair to the seller if you have a clause that allows you all the way up until the eve of closing the ability to get out, and it's not fair to the buyers if the seller says, well, I'm not going to allow any force majeure clause. Well, if I can't get leverage, meaning I can't get debt, the reality is it doesn't matter how successful I am with raising capital, because remember, the vast majority of the money at stake in these deals is the bank's money. The bank often has, nowadays, 70%, 75%. If you're lucky and you have 80% leverage, they have 80% at stake or at risk in these deals, which means that your ability to raise the equity is very significant. Don't want to undervalue that component of it. But the bank has to feel secure that it can actually deliver. So if COVID or the pandemic impacts the bank's ability to loan you the money, then you really, as a buyer, need to have that protection in your purchase and sale agreement that allows you the option of either extending the time out to allow you to close and to allow you to get the loan in place, or the ability to terminate and get your earnest money back.
Now, one of the arguments that I've been hearing back and forth a lot online is with the issue of raising capital. Syndicators just only raising money, saying, "Oh, like I'm just focusing on raising money," and the legalities behind that. And I hear that I guess it could be a bit of a gray area. So would you be able to kind of clarify that for some of our listeners?
Yeah, absolutely. The two biggest issues that most syndicators wrestle with from around the country are, one, making sure that everyone that participates, that raises capital, is a part of what we call the issuer, that we get into what we call the issuer exemption, right? These are private offerings, meaning they are exempt from public registration. So like Apple, IBM, big companies, those are publicly traded companies. Those are companies that are publicly registered with the SEC. What we're talking about, and the vast majority of these deals are done through what we call the private offering space, which means that the issuer being the company that is being sold off to investors, and the associated persons of the issuer fall into the issuer exemption, which really means that if you're going to raise capital and receive some form of compensation, cash, acquisition fee, asset management fee, some sort of back-end equity piece, you really need to be a part of the issuer, okay? Which means that you need to be a legitimate sponsor of the deal. It can't be camouflage. It can't just simply be the only thing that I'm going to do is bring my Rolodex and dial for dollars. That's not appropriate. That's not a compliant system. people that honestly want to raise capital. Now that may be the primary gifting. Maybe that's the way, that's how they shine. But the reality is there are so many more roles and responsibilities that a sponsor has to think about. Everything from underwriting, at-risk capital, physical due diligence, raising debt, not even talking about equity, asset management, investor relations, dealing with the professionals, all of these various roles. So anyone that's going to raise capital honestly has to think to themselves, can I fulfill those roles? Even if it's a smaller version of what the lead sponsor is doing. So if you're a sponsor and you're thinking to yourself, I really like to invite this person to participate because I know that they can raise capital. Okay, well then the next question is, what else can they do? And not just before you close. What else can they do after you close? So as long as they're a legitimate sponsor and they have some other roles and they're participating honestly, authentically, transparently throughout the entire process, they fall into the issuer exemption. And then the second thing is, how do I compensate people, right? So the SEC says we cannot engage in what we call transactional based compensation plans, which means we can't award or compensate people on the basis of the amount that they raise. And it makes perfect sense if you think about it. Now, given that we're in the biggest capitalist country in the world, you might think to yourself, well, that doesn't make any sense, right? The more I raise, the more I should make. Well, the SEC says we're going to side on the basis of protecting investors. And that makes sense, right? If we incentivize even sponsors or people that are participating in these deals to get more money on the basis of what they raise, then they might be financially incentivized to not tell potential investors the full truth, all of the risks associated with their investment. So to have a compensation that's compliant, your securities attorney should assist you in understanding that compensation should really be negotiated, should be fixed according to the roles or responsibilities that the sponsors are going to perform inside the entity, regardless of what money is actually raised. So there's not a mathematical formula. There's not a sliding percentage. Well, you didn't raise this, so therefore I'm going to take away some of your. That's not appropriate. So when we tell clients, make sure that the sponsors are all legit. They need to be able to fulfill all of the various, otherwise it's a non-compliant compensation plan, or it's a non-compliant kind of like framework or structure. And then make sure that the compensation that everyone's going to get, even the sponsors, needs to be not tied to the amount that they raise. It's divided up according to whatever the percentage is that you agree on up front before any money is actually raised. And so those two things, but I think a lot of syndicators, whether you're a syndicator or a seasoned syndicator, they wrestle with. And it's sometimes it's painful, right? Because if you're a seasoned syndicator and you think, well, Dugan, that means that if I invite this person to participate and they participate, but they stink, well, why couldn't I just take part of their compensation away? Or why couldn't I take part of their ownership away? Well, you got a stinker for a partner. I'm sorry. But the reality is you won't ask them to participate with you in the next deal, but you can't then turn around and take that, cut that corner and take that compensation away from them, because otherwise it wasn't a legitimate plan or structure up front. So those two things, I think, are what people wrestle with. Mm-hmm. And yes, it can be, like you said, it can be challenging to do the thing first and foremost. Everybody, thinks, well, it would just be easy if I just paid somebody some amount of money to bring me a bunch of investors. Mm-hmm. Yes, that would be easy, but it would not be right. So we want to do the right thing all the time.
Now, what you just said there, that last statement, is it possible, let's say if they are like a licensed security broker or someone like that, that would be legal then at that point if they were just raising capital, or?
Yes. So that's the one exception. And that is if you have somebody that's going to be a registered broker dealer, that means they're registered with the SEC and they also belong to what we call a self-regulatory organization, the biggest of which is FINRA. And so if you as a sponsor have found that unicorn, right? You found that registered broker dealer that is interested in raising capital for your deal, yes, you can enter into a compensation agreement that pays them a percentage of what they actually raise. The challenge for many people in the syndication space is that is like a unicorn. It's like trying to find somebody that's very interested in the size of deals. If you think about the vast majority of deals that are syndicated in the multifamily space are under $50 million, which is often the kind of the historical benchmark for institutional lending and to whet the appetite for registered broker dealers. If the vast majority of private offerings are in that space, then you can easily see that many registered broker dealers might not be interested. And if they are interested, then the question is, what do the numbers look like, right? So they think that if you're syndicating a deal and they say, and you're doing a 70-30 with a preferred return for your investors, the 30% being sponsors, and they say, well, I'll do it. I'll do it for 30% of the entire deal. Wow. That's not going to work because you're not going to put any money in your own pocket. You'll be basically working for free for a registered broker dealer. Yeah. So the challenge, and this is a part of the space that I think is lacking. So we have clients around the country. Last year we did $700 million in structured deals, largely in the syndication space. And there's not a lot of registered broker dealers that could fill that void. And I think it is something that potentially a registered broker dealer could fill and could be a very useful tool for a lot of syndicators.
Mm-hmm. So let me ask you this. You hear a lot about the Reg D and the 506B and C offerings is typically what I hear a lot of. Now, there was another one. I don't remember what it was, but I'll just describe it to you. There was another syndicator. I heard this sometime last year, and he simply did it through like crowdfunding, but really small amounts of investments. Yeah. And I just thought that was really interesting. He raised, I think it was a couple $1 million. I don't remember how much. But the one thing that I really liked about that was simply you could have like smaller investors, working class people that could also get into these syndications. And I thought that would be like a really neat model and a really nice way to actually give back to community as well. So what type of regulation does that fall under, and how exactly does that work?
Yeah, I'm assuming that it's probably a Reg A offering, which allows the opportunity for you to have both accredited and sophisticated investors and have these crowdfunding platforms. There are amazing opportunities. The challenge gets to be, so there's pros to everything in life, right? There's nothing is like amazing and easy. The reality is, if you have if you utilize a crowdfunding platform where you have, let's say, hundreds of investors and they're relatively small amount of investment, you as the sponsor still need to be treating it just as if you were syndicating a 506B or 506C and you with an investor who gave you $75,000 or $100,000. And in reality, maybe they give you $1,000 and they want to talk to you and they want to ask you questions about it. And this may be their first investment. And like you said, this may be that otherwise doesn't have a lot of liquidity. So the challenge for you is one, what does your bandwidth look like on the sponsor side for you or a strategic team member to be able to devote the time necessary to help educate and or answer all the questions. Treat them just like you would $1,000 investor, just like you would $1 million investor, from the standpoint of honestly providing them authentic information about it. So many syndicators and sponsors think to themselves, well, I don't have that. I don't have that time. Well, if you don't have that time and you're not willing to create that space, then I would say that's not an appropriate platform for you. And then secondarily, after you've closed on the acquisition, you'll have an obligation to provide them updated reports about their investment and to manage the distributions that flow out, right? So you might imagine quarterly distributions to 10 investors or 20 investors is a much easier pathway in a lot of ways than to 300 or 400 investors. And so those are some of the things that you need to deal with. But you're right. There's nothing like thinking about this. Many investors, seasoned investors that invest, and they have the ability to invest $50,000, $100,000 into a deal, they have a certain mindset versus an investor that you can honestly deliver amazing results for and to make a dramatic impact on their life at $1,000. Mm-hmm. Somebody that you would maybe you might be the spark that ignites that entrepreneurial spirit in some family member's life. And that's a change that is worthy of ascribing to. There's no doubt about it. So I think both of those types of methods are worthy. You just have to, as the sponsor, you really need to evaluate what is it that I'm prepared to do or sacrifice or devote. How much of my time, resources, and money am I prepared to devote to that process?
So for those Reg A's, the Reg A offering, are they pretty difficult to get set up? And they're pretty costly and they take a while, right?
They are. There's an approval process. They typically take months to essentially pre-approved by the SEC, and then there are restrictions on there's additional components and requirements for disclosures and reporting requirements to your investors throughout the life cycle of the asset, then 506B or 506C, and there's upfront costs. So most securities attorneys are going to cost you significantly more to set up that type of fund structure than they are to do a 506B or 506C offering. And what I tell my clients are that, listen, if you want to include, if you want to deviate from your minimum investment that you set forth offering, your private offering for a 506B offering, that's fine. That's your power, your authority, your choice to do that. And so you can include people that you want to invite in at a lower minimum investment amount doing a 506B or a 506C if they're an accredited investor. So more likely than not, what would be a 506B fund or a 506B syndication where you had friends or family, people that were in your circle, said, I would like to invest, but I only have $1,000, $5,000. Would you allow me to invest? And you knowing that your minimum investment amount may be $50,000, maybe $25,000, still have the authority to say, yes, absolutely. You can come on and invest, provided it's a suitable investment for them, provided that you believe that they understand the risks that's associated with the potential investment. Absolutely. And that might be a better alternative than the process of the long and expensive process of going through like a Reg A.
Mm-hmm. But with the 506B, like you just said, so that would basically allow some sophisticated investors on, but there are limitations to the number of people, right, that you could have as far as sophisticated investors.
Right. There's 35.
35.
To basically 35 sophisticated investors. Those are investors meet the historical criteria of what an accredited investor really looks like.
Mm-hmm.
And for most of us, we think, well, what's an accredited investor? Well, that's really somebody whose net worth is something north of $1 million. When you back out the value of their primary residence, or they have made $200,000 in the last 2 years, or $300,000 when you combine their spouse's income with theirs, with the reservation that they're going to make that in the future. Now, that's a very strict criteria. And when you think about the world's population, the vast majority of the people that we know, like, and trust do not and are not accredited investors. And so it's vital for people that have a heart of an entrepreneur and they want to syndicate and they want to offer that to other people, that you have the opportunity to include people that don't meet that strict definition. And the SEC says, that's fine. We will give you 35 slots. Now, you may think that's arbitrary, and it is to a large extent. That is arbitrary, but at least it's 35 slots that, and the only criteria is, one, is this a suitable investment for these people? And two, do you have a pre-existing substantive relationship with that potential investor that you know that they could bear the risk of loss of the investment? So I would say, the average syndication right now, you're somewhere from 35 to 50, maybe 75 investors, depending on what your minimum investment amount is. So you can see 35 is a meaningful number. It does allow you the opportunity to allow parties that otherwise wouldn't fall in that strict definition of an accredited investor. But it's important. It's important for you to understand exactly that you do have the ability to do that.
Now, one question actually that just came to mind, because I had a call not too long ago with an investor. He's not an attorney, but he's a real estate investor. It's with regards to just the overall asset protection per se. So from the perspective of, now let me just give you the story. So him and his partner, it was back in the 80s, they bought a small shopping mall. And his partner, they both kind of branched off. They held on to it for years. And it was like 20 years later, he went off and he kept buying, single families and multis, and his partner went off and got into development. Well, lo and behold, I guess when the economy turned south back in 2008, his partner got sued and they went after pretty much everything they could find. And they tried to go back. They went as far back as like 20 years earlier, and the only reason they couldn't put a lien on that shopping center was because they put that shopping center in a trust.
Yeah.
So, when we're dealing with these multifamily syndications, I mean, we're in these partnerships with other people, right? So, I mean, essentially we are open, and even our asset is open to potential, what would it be? Having liens, placed on our assets, right? So, what are your thoughts with regards to this type of situation?
Yeah, so being a litigator at my core, when I first started being a litigator for over 20 years, I have sued people and I've defended people that have been sued in the context of what we call having alter ego allegations, meaning trying to pierce there's a concept in the law, it's called the corporate veil. What that really means is there's a shield that exists between your entity and your person, and thereby shielding your personal assets from exposure to a potential judgment creditor. You participate as a sponsor in these types of deals, and you do so without an entity between you and the potential investor, between you and the potential third parties like your property manager, the general contractor if you're going to do rehab, the general contractor's workers that are performing rehab, fixing your roof on your various property. There are any number of countless contracts that exist or acts that exist on a person's property that may create exposure, meaning the possibility that I might be sued for something. And you're thinking to yourself, well, I got into this for financial freedom, to create income to leave to my kids or create a legacy worthwhile of protecting. How do I protect that? Well, the reality is you can do a few simple steps. One, remember that insurance is always your best line, your first line of defense in any attack, right? But insurance isn't foolproof. So while the lender is going to require, because remember the lender, they have the most at risk in these properties, they're going to require you to have gold-plated insurance. You are going to likely be overinsured. That means the structure, the facility, things like that. But it doesn't protect you. Insurance doesn't protect you on breach of contract or things that we say in the insurance industry that are not covered claims. So somebody suing you for breach of contract or fraud, right? Somebody falsely accusing you of engaging in fraudulent activity. Well, they lied to me. They told me that the return on this investment was going to be X, and the reality was it was Y. Even if Y is what's stated in the private placement memorandum, they can sue you for alleging claims that theoretically are not covered by insurance. So what do you have to do? Well, you have to take steps, be common sense, take steps to protect yourself. And that is, I recommend to clients, whether they're a passive investor, whether they're a sponsor or a syndicator of the deal, that they really do so through an entity. And these can be entities that you can set up that are limited liability companies that help create a shield between the person potentially trying to sue you and your personal assets. The member or owner of that limited liability company can often be your own trust, which in large ways protects the ability for a judgment creditor to actually get to those potential assets. I will tell you that in many situations, these things are over-lawyered, okay? So you do not need to go hire a lawyer and pay them $20,000, $30,000. There's a number of lawyers out there that will take lots of your money and give you the most elaborate asset protection structure possible. You don't even understand. So I'm a big believer in simplicity and making sure that you understand your structure, making sure that it's not over-lawyered, because that doesn't help anyone. It helps the lawyer, but it's not going to help the client or the investor, that all you're trying to do is protect all of the assets, the income that you've potentially generated over a lifetime. So being able to operate through an entity is key. And I will tell you, just practically speaking, in 20 years of litigating commercial litigation cases, it is very rare, it's very difficult for the plaintiff, meaning the person suing you, to pierce that corporate veil and get at your personal assets. It's very difficult. Most states have a variety of factors that they look at, none of which are exclusive, okay? So there's a variety of factors that a judge or a jury will look at when determining whether there was whether there's alter ego liability, or whether the court is going to allow the plaintiff to actually look past that corporate shield. Because in this country, in the United States, we treat the fact that you have an entity, it is recognized under the law as a distinct person. You might think, that doesn't make any sense. The entity is a person? Yes. The law recognizes the entity as a distinct person, separate and apart from you individually, which really is great, because that allows your entity to invest, your entity to be co-sponsor, your entity to be the syndicator, and not you individually. So you're not subjecting your assets to essentially exposure from third-party claims.
Mm-hmm. So it seems, definitely it seems as though, like you just said, so the operating entity for the actual syndication, the members of that, if they were to actually go in or become members as either a trust or another LLC, that would probably be best, right? So that's on, you were talking on the GP side, right? Now, what about for the LPs? Would you still have the same recommendation for the LPs as well?
Yeah, I mean, I think the LPs, the exposure an LP has in any one of these things is infant. Okay, it's very small. It's not non-existent. Okay, you're not going to get any lawyer to ever say your risk of exposure is non-existent. They won't say it, right? But understanding the practical realities of litigating these types of cases, and I don't think it's appropriate for anybody to tell an investor, man, if you don't invest through an entity, you're an idiot, or you're going to lose everything because somebody's going to. The practical reality is sue them for what? Now, I understand anybody can be sued for anything, okay? Having been a lawyer for 20 plus years, I get it. But the reality is, what exposure realistically does a limited partner, a passive investor have? Now, there may be tax benefits associated with a passive investor investing through an entity that they create. They may be able to shelter some self-employment tax. They may be able to do things in connection with their interest that worthy. And yes, even a passive investor, if you invest through your entity, regardless of the fact that most operating agreements or all operating agreements, including the offering documents, will say the investors have no responsibility for the obligations of the company, meaning no debt obligations, no responsibilities in connection of if the apartment building gets sued, right? Or one of the vendors doesn't timely paid. All of those things flow up to the management or the management entity, the sponsor, the syndicator side. None of that theoretically flows over to the limited partner side. But nonetheless, it is the most conservative approach for a passive investor to still invest through an entity, their own entity that they own and control. And that does afford them some asset protection things, does afford them some tax benefits associated with that as well.
What would be a good book recommendation you'd have for people?
I've read 2 awesome books just in the last week. Okay. One is a very short read, and it's called Goals by Zig Ziglar. It's an amazing book. It helps anyone. I don't care what your is about goals, but it'll help you shape what type of for the future. And the second one was more of like I wanted a guilty pleasure read. That is Shoe Dog. So it's the biography, Shoe Dog, the biography of Phil Knight, who was one of the co-founders of Nike. And it's a fast read because of the way that it's written. So while both of these are nonfiction books, I read almost exclusively nonfiction, but they're both excellent that I think any of your listeners should take advantage of. And I thought they were awesome.
All right. And how could our listeners reach out to you?
Hey, we'd be happy to speak with any of your listeners. You can check us out. We're on all the social media stuff. We have a YouTube channel. It's Dugan Kelley. It's my name. We have Facebook. We're at Kelley Clarke Law. Or you can check us out on Instagram, or you can just email me. My email is Dugan, Dugan, that's my first name, at Kelley, Lley, Clarke, CLARKE.com. That's our firm, Kelley Clarke. So feel free to email me. You just Google my name, and we'd be happy to connect and see if we will serve your needs.
All right. Thank you so much, Dugan. It was a pleasure speaking with you.
Thank you.